Good day. My name is Claire. My report is about General Register Number or GR number 193897. What is GR number 193897? University of the East, Dean Eleanor Javier, Ronnie Gallego, and Dr. Jose C. Benedicto, petitioners versus Annalisa F. Pipaño and Mariti de Bueno, respondents. In 1992, the Department of Education, Culture and Sports, or DEX, issued the revised Manual of Regulation for Private Schools, Article 9, Section 44, Paragraph 1, of which requires college faculty members to have a master's degree as a minimum educational qualification for acquiring regular status. In 1994, petitioner University of the East, UE, and the UE Faculty Association executed a 5-year collective bargaining agreement or CBA with effect up to 1999, which provided, among others, that UE shall extend only semester-to-semester appointments to college faculty staffs who did not possess the minimum qualifications. Those with such qualifications shall be given probationary appointments, and their performance on a full-time or full-load basis shall be reviewed for 4 semesters. On February 7, 1996, several concerned government agencies issued DEX, CHED, TESDA, DOLE, Joint Order 1, which reiterated the policy embodied in the manual regulations that teaching or academic personnel who do not meet the minimum academic qualifications shall not acquire tenure or regular status. In consonance with this, the UE President issued a university policy stating that, beginning the school year 1996 to 1997, it would hire those who have no postgraduate units or master's degree for its college teaching staff, in the absence of qualified applicants only on a semester-to-semester basis. UE hired respondent Mariti de Bueno in 1997 and respondent Annalisa F. Pipaño in 2000, both on a semester-to-semester basis to teach in its college. They could not qualify for probationary or regular status because they lacked postgraduate degrees. Bueno enrolled in 6 postgraduate subjects at the Philippine Normal University Graduate School, but there is no evidence that she finished her course. Pipaño earned 27 units in her graduate studies at the Gregorio Araneta University Foundation, but there could no longer be credited to her because she failed to continue with her studies within 5 years. In 2001, UE and the UE Faculty Association entered into a new CBA that would have the school extend probationary full-time appointments to full-time faculty members who did not yet have the required postgraduate degrees, provided that the latter comply with such requirement within their probationary period. The CBA granted UE, however, the option to replace these appointees during their probationary period if a qualified teacher becomes available at the end of the semester. Pursuant to the new CBA, UE extended probationary appointments to respondents Bueno and Pipaño. 2 years later, in October 2003, the Dean of the UE College of Arts and Sciences, petitioner Eleanor Javier, sent notices to probationary faculty members, reminding them of the expiration of the probationary status of those lacking in postgraduate qualification by the end of the first semester of the school year 2003-2004. Pipaño replied that she was enrolled at the Polytechnic University of the Philippines Graduate School. Bueno, on the other hand, replied that she was not interested in acquiring tenure as she was returning to her province. In any event, Dean Javier subsequently issued a memorandum stating that she would recommend the extension of the probationary appointees for 2 more semesters for those who want it based on the wishes of the university president. Respondent Pipaño requested a 3-semester extension, but Dean Javier denied this request and directed Pipaño to ask just for a 2-semester extension. The records do not show if Bueno submitted a request for extension. At any rate, the school eventually wrote respondents extending their probationary period, but neither Pipaño nor Bueno reported for work. Bueno later wrote UE demanding that it consider her a regular employee based on her 6.5-year service on a full load basis, given that UE hired her in 1997 when what was in force was still the 1994 CBA. Pipanio made the same demand, citing her 3.5 years of service on a full load basis. When UE did not heed their demands, respondents filed cases of illegal dismissal against the school before the Labor Arbiter's Office. For its defense, UE countered that it never regarded respondents as their employees since they did not hold the required master's degree that government rules required as minimum educational qualification for their kind of work. On March 10, 2005, the LA held that Bueno and Pipanio were regular employees, given that they taught at UE for at least 4 semesters under the old CBA. The new CBA said the LA could not deprive them of the employment benefits they already enjoyed. Since UE enjoyed Pipanio from attending her classes, and since it did not give Bueno any teaching load, they were dismissed without just cause. The LA directed UE to reinstate respondents with back wages. Dissatisfied, UE appealed to the National Labor Relations Commission, NLRC. Bueno and Pipanio questioned the timelessness of the appeal to the NLRC. They pointed to the postmaster certification that its office received the mail containing the LA's decision on March 17, 2005, and informed the office of Attorney Maison right away. But they did not get the letter on April 4, 2005. Bueno and Pipanio claimed that the 10th-day period for appeal should be counted from March 22, 2005. 5 days after the postmaster's first notice to Attorney Maison to claim his mail. On September 27, 2006, the NLRC 3rd Division set aside the LA decision. It rejected the technical objection and ruled that the 4-semester probationary period provided under the old CBA did not automatically confer permanent status to Bueno and Pipanio. They still had to meet the standards for permanent employment provided under the Manual of Regulations and the Joint Order. The non-renewal of their contract was based on the failure to obtain the required postgraduate degrees and cannot therefore be regarded as illegal. On petition for certiorari, the Court of Appeal CA rendered a decision on July 9, 2010, restating the LA's decision by reason of technicality. It held that the 10th day of period for appeal already lapsed when UE filed it on April 14, 2005. Since the reckoning period should be counted 5 days from March 17, when the postmaster gave notice to UE's legal counsel to claim this mail, or from March 22, 2005, this prompted UE to file the present petition. Respondents point out, however, that the petition should be denied since it failed to enclose a certification from the UE Board of Trustees, authorizing petitioners Dean Javier to sign the verification and certification of non-forum shopping. The following issues are presented for the Court's resolution. First, whether or not UE filed a timely appeal to the NLRC from the decision of LA. Second, whether or not UE's petition before this court can be given due course given its failure to enclose a certification from the UE Board of Trustees, empowering petitioner Dean Javier to execute the verification or certification of non-forum shopping. And third, whether or not UE illegally dismissed Bueno and Pipanio. The court's ruling: first, respondents Bueno and Pipanio contend that UE filed its appeal to the NLRC beyond that required 10th day period. They point out that the postmaster gave notice to Attorney Maison on March 17, 2005 to claim his mail that contained the LA decision. He was deemed in receipt of the decision 5 days after the notice, or on March 22, 2005. UE had 10 days from the latter date or until April 1, 2005, within which to file its appeal from the decision. UE contends, on the other hand, that the period of appeal should be counted from April 4, 2005, the date appearing on the registry returned receipt of the mail addresses to its counsel. For completeness of service by registered mail, the reckoning period starts either from the date of actual receipt of the mail by the addressee or after 5 days from the date he received the first notice from the postmaster. They must be a conclusive proof, however, that the registry notice was received by or at least served on the addressee before the 5-day period begins to run. Here, the records failed to show that Attorney Maison in fact received the alleged registry notice from the post office on March 22, 2005 that required him to claim his mail. Respondents have not presented a copy of the receipt evidencing that notice. The court has no choice but to consider a registry return receipt bearing the date April 4, 2005, which showed the date of Attorney Maison's receipt of a copy of the LA decision, a conclusive proof of service on the date. Reckoned from April 4, UE filed its appeal to the NLRC on time. Second, respondents alleged that UE failed to attach to its petition a secretary's certificate evidencing the resolution from its Board of Trustees, authorizing a representative or agent to sign verification and certification of non-forum shopping. As a general rule, the Board of Directors or Board of Trustees of the corporation must authorize the person who signs the verification or certification against non-forum shopping of its petition. But the court has held that such authorization is not necessary when it is self-evident that the signatory is in a position to verify the truthfulness and correctness of the allegations in the petition. Here, the verification and certification were signed by petitioner Dean Javier, who, based on the given facts of the case, was in a position to verify the truthfulness and correctness of the allegations in the petition. Third, respondents argue that UE hired them in 1997 and 2000, when was in force was the 1994 CBA between UE and the faculty union. Since that CBA did not yet require a master's degree for acquiring a regular status, and since respondents had already complied with the 3-year requirements of the CBA, namely that they serve full-time. Second, that they rendered their 3 consecutive years of service. And third, that their service were satisfactory, and they should be regarded as having attained permanent or regular status. But the policy requiring postgraduate degrees of college teachers was provided in the Manual of Regulation as early as 1992. Indeed, recognizing this, the 1994 CBA provided even then the UE was to extend only semester-to-semester appointments to college faculty staff, like respondents who did not possess the minimum qualifications for their positions. Besides, as the court held in Escorpizo versus University of Baguio, a school CBA must be read in conjunction with statutory and administrative regulations governing faculty qualifications. Such regulations form part of a valid CBA without need for the parties to make express reference to it, while the contracting parties may establish such stipulations, clauses, terms, and conditions as they may see fit. The right to contract is still subject to the limitation that the agreement must not be contrary to law or public policy. The State through Batas Pambansa Bilang 232, the Education Act of 1982, delegate the administration of education system and the supervision and regulation of educational institutions to the Ministry of Education, Culture, and Sports, now the Department of Education. Accordingly, in promulgating the Manual of Regulation, DEX was exercising its power of regulations over educational institutions, which includes prescribing the minimum academic qualification for teaching personnel. In 1994, the legislature transferred the power to prescribe such qualification to the Commission on Higher Education, or CHED. CHED Charter authorized it is to set minimum standards for programs and institutions of higher learning. The Manual of Regulations continued to apply to colleges and universities. To suppletorily, the joint order under 2010 when CHED issued the revised Manual of Regulation, which specifically applies only to institutions involved in tertiary education. The requirement of a master's degree for tertiary education teachers is not unreasonable. The operation of educational institutions involve public interest. The government has a right to ensure that only qualified persons in possession of sufficient academic knowledge and teaching skills are allowed to teach in such institution. Government regulation in this field of human activity is desirable for protecting not only the students but the public as well from ill-prepared teachers who are lacking in the required scientific or technically knowledge. They may be required to take an examination or to possess postgraduate degrees as prerequisite to employment. Respondents were each given only semester-to-semester appointments from the beginning of their employment with UE precisely because they lacked the required master's degree. It was only when UE and the faculty union signed their 2001 CBA that the school extended petitioners' probationary status subject to their obtaining a master's degree within their probationary period. It is clear, therefore, that the parties intended to subject respondents' permanent status appointments to the standards set by the law and the university. Here, UE gave respondents Bueno and Epipanio more than the ample opportunities to acquire the postgraduate degree required of them, but they did not take advantage of such opportunities. Justice, fairness, and due process demand that the employer should not be penalized for situations where it had little or no participation or control. Wherefore, the court grants the petition and reverses the decision of the Court of Appeals, dated July 9, 2010, and reinstates the decision of the National Labor Relations Commission dated September 27, 2006, as well as its resolution dated December 29, 2006, and February 27, 2007, that dismissed the complaints of respondents Annalisa F. Epipanio and Marti D. Bueno.